So let's talk about sovereignty for just a moment. In order to understand it, you got to know the history. So I'm sorry I'm a little bit long-winded, but there's so much detail that people need to understand. If they truly want to know how to mitigate this issue, they need to understand the concepts and the way in which we reach the point that we're at today. So a sovereign state is defined as a state that is complete in itself, not subject to a higher government's laws. That would be a sovereign state. Now, a non-sovereign state is defined as a state that is not complete in itself, subject to a higher government's laws. Okay? So when it comes to a state, such as the state of California, the state of California cannot be sovereign because it subjected itself to the supremacy of the United States Constitution. Now, the very first case that the United States Supreme Court ever heard was a case called Chisholm versus Georgia, 1793. And in this particular case, an individual from South Carolina was suing Georgia for failure to pay bonds. And he was using the Article 3 argument, the same argument that I'm bringing, which is that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, right? So anytime that a state is a party in a cause, that state cannot be judged in the cause because a maximum law is that you can't judge your own case. So if the state is a party in the cause through any one of its agents, then that means that the state must recuse itself from acting as the judge in the case. And as a result, according to the Constitution, there is a constitutional obligation that exists for the United States Supreme Court to oversee the disposition of that dispute as original court of jurisdiction. Now, the original jurisdiction means that that's the court that hears it first, the original court. No other court can hear it before the court of original jurisdiction. Because that's a constitutional obligation defined within Article 3 that the state or that the United States Supreme Court must be the court of original jurisdiction, then that means that it is non-discretionary and it's non-delegatable, because they can't use their discretion abusively to break the law and to mitigate their obligation that was created and codified in the Constitution, nor can they use the ability to delegate it to another court, because that would be altering the Constitution by a branch of government that has no authority to do it, because only an authentic act of the people is the manner in which you can amend the Constitution. So neither an act of Congress, the 1925 Judicial Reform Act, for instance, they can't change it because that would be a manner contrary to the Constitution and the special amending procedure of Article 5. But nor can a state, or nor can the Supreme Court itself say that we're not going to do it, because that would be, or rather delegate it to, say, the district court, because that would be them changing the obligation and assigning it to someone else, which would be contrary to what the Constitution demands. So until the Constitution is changed by an authentic act of the people, consistent with the procedures and processes codified in the special amending procedure of Article 5, then that's an obligation, and it's an obligation that they must fulfill. But going back to Chisholm versus Georgia. So Chisholm sued the state of Georgia, and ultimately he won. He prevailed. Now, the reason why he prevailed was because he pointed out the fact that, and this was his argument, he said that a dispute between A and B is most certainly a dispute between B and A. So if there's two parties in every cause, one being the state of Georgia, then it really doesn't matter whether the state of Georgia is petitioner or defendant, because if they change their position, it doesn't magically change the representation of the party. So, that's Law 101, that it doesn't matter whether I'm a petitioner or defendant. It doesn't change who I am. Therefore, if one is unconstitutional, then the other also must be unconstitutional, and vice versa. If one's constitutional, then the other must also be constitutional. So that's the heart of my argument anyway. But the Supreme Court came out as a 4-1 decision. They said that the states gave up their sovereignty in order to join the Union and subject themselves to the supremacy of the United States Constitution. So when the states joined the Union, right, they gave up their sovereignty because they subjected themselves to the supremacy of a higher government's laws, the very definition of a non-sovereign state. Now, the United States of America could have sovereignty, but the states may not have sovereignty because they are subjected to the higher government's laws. Now, when we were forming and going from the Confederacy into the Union, there were basically two different concepts that they were arguing. And James Madison, of course, prevailed with his approach of three separate but equal branches of governments. But the two options were, one, what was called the localist view, right, and that was the statist view. So what was happening there was that there were three questions that the Constitutional Congress needed to address, three issues. Issue number one was that there was no way to get the states to actually implement the laws that were created by the central government, right? The states were picking and choosing, what legislation they wanted to implement or not implement at the central government, from the central government. And as a result, there wasn't harmony among the nation, because when the central government created a law, then the states were saying, well, we don't want to do that. We don't want to do that one. That one's not something that we want to subject ourselves to. So they were picking and choosing what they want to do or not do. And they can't do that, right? That's not harmony. That's not a union. That's independent sovereign states. Just like the definition of a confederacy is two or more sovereign states with a loose decentralized governing structure. So issue number one was resolved by the establishment of the legislative branch, right? So question number one got resolved by the establishment of the legislative branch. Now, the second question that they had, or the second issue that they had, was that there was no executive officer that would oversee the implementation and execution of the laws at the state level. Thus, they created the executive branch, because they needed to do that, right? They needed to be able to have someone there to oversee the implementation and application of laws at the state level. And so issue number two was resolved by the establishment of the second branch of government, the executive. Now, issue number three was that there was no judicial authority to be able to make decisions that would impact all of the regional governments, right, through a court of last resort. And so thus they created the judicial branch. They created three separate but equal branches of governments to address the three issues that we were facing as a nation at the time of our migration from the Confederacy into the Union. And ultimately, James Madison's concept of the three separate but equal branches of governments prevailed, because it was not. See, the statist view was that they wanted to be able to keep sovereignty at the state level, and just increase partially the participation at the central government level. So the two options were the localist view, where there's sovereignty at the state level, and the local government had more power than the central government, right? And that would be maintaining the Confederacy, or creating a union with three separate but equal branches of governments, with the states subjecting themselves to the supremacy of the United States Constitution and the higher government's laws. So the issue of sovereignty doesn't exist, because so the Supreme Court, very first decision that they made, Chisholm versus Georgia, said sovereignty doesn't exist. States gave up their sovereignty in order to join the Union and subject themselves to the supremacy of the United States Constitution. Well, what happened then was that the states threw a fit, and they're like, "Oh no, this is bullshit. We're sovereign, and this can't be." And right or wrong, we passed the 11th Amendment in 1795. Right or wrong, I would say that it's wrong what happened, but nonetheless, we passed it. It's law. It was agreed upon by the people of the United States by an authentic act in accordance with the Special Amending Procedure of Article 5. But the problem is that the 11th Amendment, if you read it, it only says that a citizen in one state cannot sue a different state. That's all it says. It says absolutely nothing about suing your own state. It says that you cannot sue a different state. So it partially overruled the Chisholm issue, right, by saying that, okay, a guy in South Carolina can't sue Georgia, right, but it didn't say anything about suing a person residing within Georgia suing Georgia. It doesn't say that. Nowhere in that does it say that. And now, over the next 100 years, we have major cases like Martin versus Hunter's Lessee, McCullough versus Maryland, and Cohen's versus Virginia. These huge cases, Supreme Court landmark cases, that all say that states are not sovereign, consistently say that. And so then you fast forward to 1890, a case called Hans versus Louisiana under the Waite Court. Now, the Waite Court, Waite was well known to be a slave sympathizer. He made a whole bunch of rulings that were terrible, such as Plessy versus Ferguson, Hurtado versus California, the slaughterhouse cases, Cruikshank versus United States. I mean, the civil rights cases. These are all cases that are terrible, horrible decisions, and yet he made them. So what happened then in Hans versus Louisiana was an individual was suing his own state, Louisiana, and the court said, well, and this is what they said, and I'm paraphrasing it slightly here, but they said that we're not reading the 11th Amendment literally, we're reading it figuratively, and we believe that it interprets that the states are sovereign. Thus, sovereign immunity is born. Now, the problem is that the Supreme Court has no authority to alter, amend, or destroy the Constitution of the United States by judicial fiat. And yet that's exactly what they did. They said, we don't read the 11th Amendment literally, we read it figuratively, and we believe that it interprets this, although it doesn't say that. Now, what's important is fast forward to 1996. It was a case called Seminole Tribe of Florida versus Florida. And it wasn't that they overturned sovereign immunity, but what happened was the dissent was written by Justice Souter. What Justice Souter said was he said there appears to be two versions of the 11th Amendment that exist. One enacted by the people in 1795, the other conceived by this court almost a century later. The point is that the United States Supreme Court has no authority to conceive law, nor conceive an alteration of the Constitution of the United States. And when they did, they created something that was not valid. It was not lawful because it was created by a branch of government that had no authority to alter, amend, or destroy the Constitution of the United States. There is no sovereignty.